Welcome, everyone, and thank you for being here for this webinar. My name is Dave Relling, and I'm the president of the board of directors for the Federation of State Boards of Physical Therapy. FSBPT continues to utilize these regular webinars to provide educational content on key issues impacting regulation and also to provide foundational content for all of us as our role as regulators during these regulatory hour webinars. The FSBPD board recognizes the challenges facing regulators. We want to hear from you, understand the jurisdictional specific concerns that you might have, and also how we can help as the Federation of State Boards of Physical Therapy. If there's anything that I can do or a member of the board of directors could do or staff, please reach out to us and see how we can connect you to the right person and the resource to be able to support your role. Today, we're very excited to have Jennifer Semko back for another regulatory hour. Today's topic is legal landscape related to AI. Jennifer is a partner in the Washington, D.C. office of Baker McKenzie's global law firm, where she chairs the office's litigation and government enforcement practice. Jennifer has more than 25 years of experience litigating disputes in state and federal courts across the country and internationally. I'll refer you to her full bio on the website to be able to get additional information. Questions during the webinar can be submitted in the chat, or you can wait till the end and ask those questions. We are going to hold all questions till the end of Jennifer's presentation. Also, please remember we are in a virtual meeting, so please mute your microphone unless you want to speak to the group at the end of the meeting to ask your question. And with that, I'd like to please welcome Jennifer in her presentation.
Thank you, Dave. Hi, everybody. It's good to be with you again virtually. I am here, as Dave said, to talk about AI, which, there's really no hotter topic right now. Everyone from ages 10 to 110 is talking about, thinking about, and witnessing lots of AI. And so it makes sense for us to touch on this topic to get a better understanding of how it might affect the world that we are all operating in, including with respect to licensure examinations and regulation around licensure. So with that, let me preview for you what I hope to cover over the next hour, leaving some time, of course, for questions. First, I always feel like it's good to take a step back and think about the bigger topic at hand. What is AI? What are the good and bad parts of AI as we currently know it? I want to share with you an overview of the current status of AI regulation in the United States. Things are very much in flux, evolving very rapidly, but I'll give you a decent sense of where things stand as of today, fully recognizing things could change and are changing moment by moment. Of course, as a litigator by trade, I would be remiss if I didn't talk to you about the significant AI litigation risks and some of the trends we're seeing in terms of lawsuits that have been filed based on the use and implementation and development of AI. I'll spend a little bit of time talking about how AI disputes have come up in the context of testing specifically. And then lastly, in hopes of getting us all thinking about these issues and how to make the most of AI while also mitigating our risk, I'll share some recommendations and things to think about in terms of reducing the risk you might experience when it comes to using AI. All right, so stepping back to the 20,000 foot level, let's ask ourselves, what is AI anyway? There really isn't a single universally accepted definition. And the bullet you see up here, the second bullet, I asked AI, what is AI? And this is the answer that it gave me. The ability of computer systems to perform tasks that typically require human intelligence. Well, in a sense, that's what a computer does and has always done going back many decades before we started talking about AI. But really, as that term has come to the fore, we're really thinking about machines learning, solving problems, and maybe most importantly, and as we'll see when I talk about some of the litigation that's happening, making actual decisions instead of humans, perceiving things and reacting to its perception. ChatGPT tells me that AI can be designed to mimic human cognitive functions or to automate processes that humans would otherwise perform. There's tremendous potential wrapped up in that. What might take Dave and me an hour to do, a computer, an AI tool could do in a fraction of a second. There's something incredibly powerful about that. But also, if that computer is being relied on to make decisions that affect other people, something a little bit scary too. And of course, if you're working and living in the testing industry and lots of other industries, you've encountered a subcategory of AI known as generative AI. That's AI that actually creates new content like text or images or audio or video in response to a prompt that it receives. If you've spent any time on Facebook or Instagram or TikTok, you've seen these AI videos, things that look or sound just a little bit off. Maybe you can't put your finger on it, but it turns out it's not real. It's AI generated. So this generative AI, again, tremendous potential, tremendous potential use, but also a little bit of risk and danger. So as AI has become more and more pervasive, it feels like everybody and their brother is jumping on the AI bandwagon. Are you using AI? Oh, I'm using AI. And why aren't you using AI? So it can be a little bit intimidating, and we can all feel pressure in our professional lives to tap into this potentially very powerful tool. But as any lawyer worth their salt will tell you, it needs to be implemented and used with a bit of caution. It is so new. No one knows exactly where it's going from a technological perspective and from a legal and regulatory perspective. It still remains to be seen how it can be used, what other functionality and options might be open in the future, and what risks those might present. And most unsettling is the fact that the whole regulatory landscape around AI and court decisions related to AI are very much still evolving. And as a practical matter, when it comes to AI, there's still a lot of kinks to be worked out. What do I mean? I'm sure you've lived through it, but for example, if I ask an AI tool, generate for me a picture of wiener dog races, you might get something like this. That is not exactly what we had in mind, but the computer, the tool, took the instruction quite literally and gave me something like this. If I ask for a picture of a salmon fisherman, I might get something that looks a little bit like this. So a little bit imperfect, to be sure. If I say, hey, I'd like a picture of my husband mansplaining to me how to eat a cheeseburger, again, these are the sorts of things, comical, but at the same time, just highlighting for us that this technology is not yet perfect. It has a lot to learn in some respects. And those of us humans who are working with AI still have to be very aware of its limitations. You may have read in the news about lawyers, and there are dozens and dozens of them, who've gotten into some trouble using some of the AI legal tools that are now available to draft briefs that they actually submitted to courts, briefs chock full of completely made up cases that do not exist. At least a dozen lawyers have been sanctioned by their state bars for doing this because the AI, particularly earlier generations of certain AI tools, tend to what we call hallucinate and grab information and data and, like this photo, give you what it thinks you want, not realizing that just making up things that don't exist is not very helpful. So knowing the power behind these tools, but knowing the risks, our state, local, and federal government officials, legislators have been thinking and working on how to regulate AI. But at this time, when we think about federal regulation, there really isn't anything yet on the books, nothing comprehensive that provides guardrails around the use of AI. Now, President Trump and before him, President Biden have taken some steps to try to start to build some federal principles around the use of AI. President Trump in January issued an executive order called Removing Barriers to American Leadership in AI. That gives you sort of a sense, a flavor of what he was trying to achieve with that executive order. And it actually rescinded a prior executive order of President Biden. The new Trump order calls for federal agencies to either revise or completely rescind all of their policies, regulations, or directives that President Biden might have put into place under his administration if they are inconsistent with his goal, President Trump's goal, of enhancing U.S. global dominance in AI. What does that mean? It's still a little unclear. But federal agencies right now are grappling with this instruction to prioritize American dominance in AI and arguably making more secondary concerns about potential risks of AI. So hitting that right balance is really the struggle that governments at all levels are facing. In Congress, potential legislation has been brewing for quite a while. Nothing yet has been passed. There have been different pieces proposed, but we still don't have a comprehensive AI bill in place. There was for a while in the One Big Beautiful Bill a provision that specifically said for a period of 10 years, at least initially it was 10 years, during negotiations it got whittled down and then eventually completely removed. But for a period of time, this provision would have required that states and local governments not impose any regulation of AI and leave it all to the federal government. That was a bit controversial, and that was stripped out. So the moratorium against state regulation of AI almost made its way through that bill, but did not ultimately succeed. Now, all that being said, even though we don't yet have a comprehensive federal AI law, there are some existing federal laws that are used on a regular basis when it comes to regulating AI. And I'm talking about things like antitrust laws, copyright laws, anti-discrimination and civil rights laws. I'll touch on a few cases in a minute, but people are already putting old laws to use in this new territory. So what about on the state side? Well, without any comprehensive federal law, the states have been stepping in to fill those gaps. And the state of Colorado really went first. Colorado passed the Colorado AI Act. It's the first relatively comprehensive AI legislation that was passed in the US. It won't take effect until next year, but it creates some duties for those who develop and those who use AI. And it's mostly focused on high-risk automated AI decision-making systems. So I mentioned a minute ago that AI can be deployed to analyze and then make a decision that a human would previously have made. And that's the kind of use of AI that Colorado is really focused on. So if there is a system in use in Colorado, an AI system that plays a significant role in a decision that has a material effect on consumers related to education, employment, government services, healthcare, insurance, legal services, important aspects of life like that, then it will fall within this Colorado law. And the Colorado law is becoming a template for a lot of other states that are mirroring or following it. Connecticut, Massachusetts, New Mexico, New York, Virginia. Those are just a few of the other states that are currently considering or have recently passed legislation modeled after this Colorado Act. California, which often leads the charge in the development of new law in new territory, it has passed a number of AI laws last year, 2024, and more laws are under consideration there. Many of them are focused on AI and its effect on the entertainment industry. Things like deepfake, the Deepfake Deception Act, use of likenesses, Digital Replica Act. But as time goes on, California is considering even more broadly applicable laws. Texas has stepped in with the Responsible AI Governance Act that became law this summer. It's a more narrow version of the Colorado law. And one thing I wanted to also flag, if things weren't already complicated enough, we're seeing AI laws at the city and local level. So for example, in New York City, there was an ordinance recently passed that prohibits employers from using AI tools to screen resumes or make any kind of hiring decision unless that tool has undergone a bias audit. So as we'll hear in a minute, there's been a lot of litigation over employment-related AI tools and whether they are fair or not to people in certain groups. And so the city of New York is attempting to make sure that any such tools are really bias-free before they're used by New York employers. And of course, just like in the federal system, there are lots of pre-existing state laws that have been triggered in the context of AI, laws governing privacy rights, trade practices, negligence, you name it. People are finding ways to take the existing legal tools that we have and apply them to this very new territory. So anytime you have a new and exciting technological development, creative uses of that technological development, and lawyers, you put those three things together and you're going to have lawsuits. And we are definitely seeing litigation when it comes to AI. There's been a lot in the news, and there are some other types of litigation that is brewing more in the background and may become more publicly known in the future. But when you think about AI litigation, some of the most prominent lawsuits we're seeing relate to things like copyright infringement, consumer privacy, and as I mentioned a moment ago, employment. But there are other areas that didn't get as much attention in the news, but we're seeing more and more lawsuits emerging. Things like negligence and product liability, false advertising, unfair trade practices, and some other alleged harmful outcomes that plaintiffs are claiming as a result of AI. And cybersecurity risk is certainly another area as well. And when you think about risk, you also think about protecting against that risk, such as through insurance. That's another really interesting area that a lot of folks are thinking about right now. So let's dive a little more deeply into some of these risk areas. Given FSBPT's role in the licensure exam space, it's important to think about copyright, of course. And those of you who've heard me speak about copyright know that high risk licensure exams and other forms of exams are typically protected by US copyright laws. And that gives you a lot of important tools in your toolbox to protect the exam, to keep it safe and secure and valid and reliable. So when it comes to AI, however, there's some interesting copyright issues triggered Um, Most of the lawsuits we're seeing involving AI and copyright center around the argument that AI developers are improperly using copyrighted materials to train their AI models. And that raises some really interesting questions. Is that really copyright infringement? It's all happening in the background. The machine is taking in news articles or novels or photographs or test questions and generating new content based on what it learns from what has been input. Is that copyright infringement, or is that just fair use? And these are the questions that are working their way through the courts right now. What the defendants in those cases usually argue are things like, well, my use is transformative. I may have taken your copyrighted materials, but what I am putting out into the universe is something completely different and something completely new. And what I'm putting out doesn't affect the market for your original work. So a lot is going on. Most of these lawsuits are pending in either New York or California. California being the home of a lot of tech companies and AI developers, and New York being the home to the publishing world, a lot of media companies. And so as a result, some observers have concluded that the California courts seem to be more favorable to AI developers, while the New York courts, in their rulings so far, seem to be favoring the content developers. Now, that may, in the long run, not prove to be the case, and we've seen decisions kind of going both ways on both coasts. But there's a lot happening in those two states right now. You probably have read about some of these cases in the news, but one that really stands out, and I think lots of folks are watching to see how this evolves, is New York Times versus Microsoft and OpenAI. That case has been pending for about 2 years now, and it involves a suit by the New York Times, which accuses the defendants of using their news articles to train their AI tools, like ChatGPT, to create products that are essentially competing with the New York Times itself. And the New York Times, working with these AI tools, was able to recreate instances in which ChatGPT regurgitated full Times articles, word for word. And the defendants, in response to that, say, well, that's a fluke, and that's something we are working to program out of our tools. That's a bug. We don't want to just copy your articles. But the New York Times is arguing that's simply not good enough. You cannot use our copyrighted materials to educate your AI tool. Lots of very similar cases have been filed by other news outlets, and they are all working their way, as I said, through the courts. In California, we've got the West Coast version of that litigation, and the plaintiffs there are often in the media and entertainment world. We are seeing in Delaware a similar suit involving photographs and images. In Tennessee, Nashville, country music capital of the world, we are seeing litigation involving music and alleged infringement, copyright infringement of certain musical works. So a lot is really going on in the courts right now, and there's not a lot of guidance yet, but as the years go by and the courts start to settle on certain principles with respect to AI's use of copyrighted materials, I think things will become a little more clear. So that's on the defensive side. But what if you are the creator of a copyrighted work and you want to protect it? Like I said, test questions, test content is copyrightable. If a test prep company or an unscrupulous test pirate steals your exam questions, you want to be able to protect them. But what about test questions that you generated using AI tools? Are those just as protected as test questions that were created 100% by humans. This also is rapidly evolving. The U.S. Copyright Office has made it clear that works not generated by a human are not copyrightable. But when you've got a combination of AI and human creation, there may be copyright protection. It's a gray area. The Copyright Office has issued some guidance, but there are still a lot of open questions about where that line is drawn between a human-generated work that can be protected and a computer-generated work that cannot. So I mentioned privacy. That's another significant area of risk, and another significant area in which we're seeing a lot of litigation. It's increasing, but privacy litigation accusing AI of violating consumer privacy rights has stumbled a bit out of the gate, and there have been some early victories for the defendants in those types of cases. Most of these cases, at least the most noteworthy ones, involve the alleged improper collection of personal data by AI tools. So there were a couple of really highly publicized cases in California alleging that personal data was being collected from the internet in order to train AI models. And the allegation there was that these AI model developers were out there scraping massive amounts of personal data with no consent by the individual humans, because that would be virtually impossible to obtain. And like I mentioned earlier, these plaintiffs used pre-existing laws to bring legal claims, unjust enrichment, invasion of privacy, state laws, the Electronic Communications Privacy Act, and they very creatively cobbled together a lawsuit based on this alleged violation. Those cases, however, were dismissed last year. So that is leaving privacy advocates to look for different ways, different methods to stop AI developers from getting and using personal private data. You may have heard of BIPA, which is a special statute in Illinois that provides protections for Illinois residents with respect to their biometric data. There's been a lot of litigation involving BIPA, claiming that vendors, sellers of AI tools are using things like facial recognition and using lots of photographs of humans that they've gathered from around the internet and without consent and in violation of these laws. So we are still seeing those working their way through the courts. There was one very significant settlement of that case not too long ago, a facial recognition software company that offered a tool that was used by law enforcement and retailers. They were sued for billions of dollars, alleging that they were improperly hanging on to images of ordinary humans who had not given consent for those images to be used to train their AI model. That case was settled for $51 million. But what's really interesting is that part of the settlement gave the plaintiffs an equity stake in the company, in the AI developer. I think that's a really fascinating way to structure a settlement. But that case is ongoing. Some of the state attorneys general have brought suit against that company, and they have opted out of the settlement. So it remains to be seen how all of this shakes out. But there's a lot going on the privacy side for sure. Employment, as I mentioned before, another potentially risky area if you're going to use AI tools. Employment litigation is on the rise as companies are increasingly hearing about and starting to use AI on the hiring side and to carry out other HR functions. So for example, there was a federal lawsuit filed in California brought by an African American man over the age of 40. And his allegation was that his employer his wannabe employer, the employer he was applying to, was using AI-driven tools that screened applicants using algorithms. And his allegation was that the algorithms discriminated against applicants based on their age, their race, or their disability. And that case is ongoing. The EEOC has settled cases that are very similar, alleging that employers were using a tool that automatically rejected older applicants because of their age. There was a lawsuit filed in Massachusetts in which a tech company was selling AI tools that the plaintiffs claim violated state law, which prohibits the use of lie detectors by employers. The argument there was, if employers can't use lie detectors, how can they use these fancy AI lie screeners in their online interviews? And all of this is raising some really interesting questions. If an AI tool allegedly discriminates, who's liable for that? Is it the employer? Is it the vendor selling that AI tool? Is it both of them? That is a controversial question that a lot of state legislatures are debating right now and thinking about as they contemplate AI-related legislation. The California Supreme Court, by the way, ruled 2 years ago, so they were really ahead of the curve, ruled 2 years ago that the vendor of an AI tool can be held liable as an employer's agent under the California Fair Employment and Housing Act. So the vendors are not off the hook simply because their tools are being used by others. I mentioned earlier, before we leave the employment segment, that in New York, there's a specific ordinance prohibiting the use of AI screening tools unless they have undergone that bias audit. Colorado was actually the first state to prohibit employers from using AI to discriminate against workers and requiring certain steps to look for algorithmic discrimination. And then Illinois has passed laws requiring employers to actually notify applicants and workers if they're going to use an AI tool for any kind of hiring or discipline or termination decision. So those of you who may be tempted to use AI tools in the employment context, think carefully, talk to the vendors about what protective mechanisms they have in place, and certainly get to know the particular laws applicable in your state before going down that road. Another area where we're seeing AI risk that you might not ordinarily think of is with respect to products, hard, in your hands, tangible products. And there's still, again, a lot of gray area as courts try to figure out the proper way to evaluate negligence claims or product liability claims against allegedly defective products that are using in some way AI. So what am I talking about? Think hypothetically about a self-driving car that uses AI to identify hazards on the road, to read street signs, and to steer and drive the car. And imagine hypothetically that something goes wrong with the AI that's running this car and it drives off a bridge and hurts the passenger. Who's responsible there? The car manufacturer, the producer of the AI software, and how do you judge or evaluate the negligence of those defendants? If the AI was designed perfectly using the most modern and well-accepted procedures, is that enough? Or do you evaluate this situation like you would a broken toaster or another product that actually has a defect? This car was working fine. The AI tool was working fine. It just misjudged perhaps a hazard on the road. Is that a defect? Is it not? There are lots of issues that are very unsettled when it comes to product liability. And this has led to some very interesting and sad, frankly, litigation. I can tell you about one case that was just filed earlier this year. An AI developer was sued after the parents of a teenage boy alleged that the chatbot that AI developer developed through prompts in a computer conversation with the son led him to commit suicide. And that has raised a lot of unanswered legal questions about who is responsible in that situation. Is there First Amendment protection in that situation? What is a defective product when you're talking about AI chatbots that interact with human beings? And that kind of lawsuit is becoming more and more common. Plaintiffs are increasingly pursuing lawsuits against social media platforms, alleging that AI-powered recommendations or feeds are defectively designed and can cause harm like addiction or mental health issues. So it will be something that legal specialists will be carefully monitoring to help guide companies that want to use or develop these tools, but are also mindful of the risks that they carry. And once again, it raises such intriguing questions about who's really responsible. And knowing that many of you, live and breathe healthcare, this raises interesting questions in the healthcare space too. What happens if an AI tool leads to an improper medical diagnosis or a surgical error or improper treatment plan? AI is constantly learning, and let's say you have an AI tool used in the healthcare space that is spot on accurate 99.9% of the time. But that 0.1% of the time, there's an error and the patient is harmed. Is the AI tool somehow culpable for that? If a human doctor had that kind of record, they would be applauded. But if an AI tool makes a mistake, at what point is that tool liable? And what about bias risk? As I mentioned, that is raised repeatedly. Is there a risk that these AI tools can be unfair or make decisions improperly based on how a human looks, their size, their age, the color of their skin? Regulators, the FDA, lots of folks are keeping a careful eye on the technology as it develops and are thinking about how to put some regulatory guardrails around it. Then we have other types of claims that come out of the use of AI: false advertising, unfair trade practices. The Federal Trade Commission last year announced that it had come up with an initiative called Operation AI Comply. It is targeting lots of different companies that use or sell AI technology that can be deceptive to consumers. And so a lot of focus right now is on whether companies are using AI unfairly or in a way that is deceptive. I can give you an example of a company that rolled out AI lawyer services, and they said, "We are the world's first robot lawyers," whatever that means. The Federal Trade Commission didn't like it because they found that the company had not adequately tested the AI outputs to determine whether what the chatbot was giving as legal advice was actually right. And that company didn't have any lawyers on its staff. And they ultimately, in the eyes of the Federal Trade Commission, were offering ineffective, unlawful services. So those sorts of things are also being watched very, very carefully. And there are lots of other types of harm that consumers have alleged has resulted from AI. One example are a fair number of wrongful arrests as a result of AI face recognition tools. So There have been many individuals who one day they're minding their own business, the next day they're being picked up by the police because some AI system has picked them out of a crowd and matched them to a photograph of a known criminal who has been a fugitive. And so we're seeing lawsuits against police departments, sheriff's departments, in various places in the country where the plaintiffs are saying, that was not me. You confused me with someone else because you used this AI tool. And there are also private retailers that have been using this facial recognition software for a while too. And from time to time, the facial recognition software makes a mistake and falsely either detects crime happening in the store when it is not, or matches a person to a prior criminal improperly and leads to embarrassment or arrest and lawsuits. So a lot is going on. In the housing world, we are also seeing accusations of poorly functioning AI. The federal government has sued a social media company saying that its housing related ads are discriminating against consumers by funneling certain ads to certain users based on their race, their socioeconomic status, and things like that. So allegedly discriminatory AI tools. There have been at least 6 class actions filed in California against a bank. And the allegation is that that bank is using an AI algorithm that discriminates in violation of the Fair Housing Act. And the claim is that the AI tool, which doesn't have sufficient human oversight, is infected with racial bias, that it is choosing interest rates and other important loan terms based on the race of the customer. And so those lawsuits are ongoing. I already told you about the hallucinations that have gotten a lot of lawyers in trouble in writing briefs, but there have been other hallucinations as well that have led to litigation. One poor guy, he's a Georgia radio host, and he's very much a Second Amendment right to bear arms advocate. AI confused him with someone else, and when a newspaper reporter was doing some research on this Georgia radio host, AI told the reporter, hey, this guy has been accused of fraud and embezzlement, and he's a criminal and a bad guy. Now, thankfully, that reporter was sharp enough to realize that maybe the AI was hallucinating. So instead of writing a story about how this radio host was a bad guy, he actually picked up the phone and called the radio host and said, you should know ChatGPT is saying some not nice things about you. And so the radio host filed a lawsuit claiming defamation. His suit was ultimately dismissed in part because the court said, you weren't harmed. No, nothing bad happened to you. You didn't actually suffer any reputational harm or damage. But this is just an indication of some of the potential risk when AI hallucinates and defames an individual. We have also seen a fair number of cases where chatbots have falsely accused people of being participants in the January 6th riot at the US Capitol. So these sorts of things are happening and working their way through the courts, just like all the other categories of legal action. Insurance, I won't spend a lot of time here, but it's just another intriguing question. Does a company or an individual's liability policy cover bad acts committed by AI? It's an interesting question, and how will insurance coverage evolve in light of everything that we're seeing? So that brings us to the testing world. What does all of this mean for tests, licensure tests, college admissions tests? Well, the short answer is the testing industry is not so different from every other industry that is facing these issues. There are lots of exciting tools that are becoming available and coming onto the market, but you've got to be very careful. And there are some risks associated with using AI. I already talked about the copyright related risks. So if you want to use an AI tool to create a whole new batch of NPTE questions, for example, and you input your prior NPTE questions into the tool in hopes that it can generate new variations for you, what is that tool going to do with all of that very sensitive, confidential content you have plugged into it? That's a really important question to ask. Is the machine learning going to result in your content being used for other customers of this tool? Or are you dealing with what they call a walled garden, where the input never leaves your particular item writing exercise? And then there's the flip side. If you're using an AI tool to generate test questions, where is that tool getting its knowledge from beyond your own content? And is there a risk that the tool is pulling in copyrighted materials that might belong to someone else, someone who might in the future accuse you of infringing their copyrights or stealing their materials? And just like I talked about potential bias in AI screening tools for employment, there are a lot of screening tools being rolled out at test sites and to provide exam security during remote proctored exams. Some of the same issues have arisen with scrutiny of those tools. Are they treating people fairly? Are they able to really detect security problems? Or are the algorithms of the AI picking on certain categories of people more than other categories? So lots of food for thought in the testing world. So I thought we could talk a little bit more about writing test questions using AI. Does anybody remember this photograph? It was very famous a few years ago. This is a selfie taken by a macaque. He took it himself. This little monkey took this selfie himself. And there was a huge legal battle that made it all the way up the federal court system to the Ninth Circuit, with the question being, does this monkey own the copyright in his selfie? It became a valuable photo, lots of money to be made. But the question was, who owns the copyright in this photo? Is it the monkey? Is it the guy who owned the camera equipment that he set out and that the monkey grabbed and used? Well, the Ninth Circuit answer was basically, it belongs to no one. It doesn't belong to the monkey because he is not a human, and only humans can hold copyrights. So that case, although the connection might not be immediately obvious, a lot of folks are looking at that case when they think about AI and copyright. So if a monkey can't own a copyright, a computer cannot presumably own a copyright either. So is generating new test questions using AI as easy as it sounds? I push a button and I've got 3,000 new items. Well, not necessarily. As I mentioned, you may, depending on the tool you're using, be exposing your content to others. So you want to make sure you carefully consider where that content that you put into the machine learning, where it goes when you're done with it. There's a risk that the AI is using others' content. Got to make sure you think carefully about that and talk to your AI vendor about that. And then again, can you copyright the questions that the tool generates for you if no human being is touching those questions? And the answer to that is, if the monkey can't own the copyright, neither can the computer. So the key there is to have a human involvement in the development of the item. Even if the initial draft perhaps is generated by AI, you've got to make sure that humans are still touching that question, working with that question, so that you can in good faith say to the Copyright Office, this is a human generated product, just assisted by AI. And that has the added benefit of making sure that you are applying proper assessment and educational standards to the development of your items as well. So has there been any litigation involving the testing world and AI? No surprise, there certainly has. I've got a couple of examples up here. Just a few months ago, a student at Yale has sued the university after he was accused, he says falsely, of using AI on his final exam. So the school, the university, was implementing a special AI tool that would look at the essays and try to detect when a non-human had written the essays. And this student was not a native English speaker. And so his English, his writing, perhaps didn't flow as smoothly as it might for a native speaker. And his argument in his lawsuit is that this AI tool is biased against non-native English speakers and thus is artificially claiming AI work product when he really wrote it himself. So that case is ongoing. You probably heard about what has happened with the California bar exam this year. It's been quite controversial. The California bar, for the first time, rolled out its exam on a virtual platform. There were a lot of technical issues. The system crashed. There were delays in typing and seeing your answer show up on the screen. People were getting error messages. They couldn't save their essays. That was bad enough. But a few months after the exam was administered, it came to light that the bar had used AI to craft 29 of its questions, 29 out of 200. So seemingly a relatively small amount. But the real problem, I think most would say, is that nobody knew they were doing this. And there was a tremendous uproar, even though the California bar had run those questions, those 29 questions, through its normal content validation panels, its item writers, its subject matter experts. They reviewed and modified the questions, but the public, the legal community, even the California Supreme Court itself, they were all very upset to find out that these were AI-generated questions. So now the bar is being audited. The executive director has had to resign. A lawsuit has been filed. Some passing scores have been adjusted. It is, one example of some of the risks of using AI. And I think many have asked the question, would this have been received differently, perceived differently, if the California bar had made it more clear upfront and had been transparent about the use of AI in generating its questions? And then lastly, over the 20-something years I've been working with testing programs, it's usually test prep companies that are being sued, but in this case, a test prep company did the suing. The test prep company alleges that Quizlet, which you may have heard of, my 3 kids have used Quizlet before. It's an online study platform. That Quizlet violated its copyright in its nursing exam test prep materials because Quizlet users were uploading the test prep company's study materials, and then Quizlet was using that to train its AI models to generate new practice materials for folks. And the test prep company's argument is, you're using our stuff and now you're competing with us, and that's affecting the market for our product. So that case is working its way through the courts as well. So I've thrown a lot at you, lawsuits galore. You might be thinking, I am never touching AI again, but that would be a shame. There's tremendous potential in AI, but is there anything we can do to reduce the risks that can come from using AI? These are just a few thoughts, obviously from the perspective of an entity that administers an exam, but you could really apply this to a variety of companies. For one thing, stay up to speed on regulatory developments. Make sure you know what the law is regarding the use of AI in your city, your state, and eventually perhaps we'll have federal legislation and more countrywide standards. Keep an eye on litigation trends and outcomes. If others are being sued for a particular issue, you face that risk as well. So just keeping an eye on what's happening. Carefully evaluate any AI tools that you might want to consider using. I talked about asking questions about where your content goes when you plug it in to the tool. What resources is the tool drawing from to provide output to you? And is there any risk to you based on where that's coming from? If you are signing a contract with a vendor that offers these tools, take a look carefully at that contract. Who's responsible if a problem occurs, if there's a claim of infringement? Does the contract allocate that risk? Internally, any entity that is using or allowing its employees to use AI should develop acceptable use policies, other policies. Maybe your policy is you can't use AI. And if that's the case, you need to make sure that's crystal clear and communicated to employees in your organization. And then related to that, when you think about exam development and the exam development process, you rely not just on employees to develop the exam, but volunteers. And some of you on this call may be volunteer item writers. It's important for that group of very important subject matter experts to know what they can and cannot do when it comes to using AI. If I'm an item writer and I'm going home and my homework is to write 10 items this week, can I use an AI tool? Is that forbidden? If I can use it, are there any limitations on the use? So that's a mouthful. And we're nearly at the top of the hour, but I'll pause here in case there are any questions.
Thank you, Jennifer, for an excellent presentation. There were a couple questions, and I'm just going to grab those from the chat here. Ian asked a question regarding copyrights. Although the NPTE is copyrighted, there's plenty of information related to the construction of the NPTE, including sample questions that are public information. AI has access to that public information. How do we regulate AI using the sample practice NPTE questions to generate further practice questions that are then marketed as such as practice questions? Any thoughts on that?
Yeah, well, you can't really stop that. I mean, that possibility existed before AI, just through test prep companies using human beings who look at retired published NPTE questions and try to design new practice items for their customers. There's nothing wrong with them doing that, so long as they're not revealing confidential information, which in this case wouldn't be happening, and so long as they're not infringing copyrighted materials. And that's where it can get a little interesting. The AI may generate something on its own that just by coincidence is very similar to a live NPTE test question. And that would be a battle over whether it was a legitimately written question or one that was copied from real exam content. But the long and short of it is that there's no doubt these AI tools are scraping the internet and looking all around and gathering up so much information, and it might be used to develop study materials, and that can be perfectly legitimate. It's when the AI gets its hand on your confidential, actively used test content that you can have a real problem. And how would the AI tool get its hands on your live, actively used content? Because you give it to the AI tool, perhaps to help you write some new questions. So that's why we've got to be really careful in making sure that what we are putting into the tools as developers of exams isn't then getting out into the universe.
Yeah, making sure it's very restricted, or that walled garden, I think that you had mentioned
Right.
earlier. One more question, kind of related to the informed consent, like you talked about with the California bar, right? So telling when AI might have been used. What is the PT and PTA's obligation to inform the patient that they are using AI for things such as documentation? And does it depend on how it is being used, recording the conversation for AI transcription versus taking notes that are later fed into the AI? and then generating treatment summaries. Any
Yeah.
thoughts on that?
It's a really good question, and the answer is going to be it depends. It depends on your jurisdiction in particular. That's part of the problem with that about not having a comprehensive federal law yet and having this patchwork of state laws. Some states are completely silent on the AI situation, and some states have more fully developed laws. I think it would be important to check the states in which you are practicing to see what restrictions are in place. I personally think it's never a bad idea to just let patients know, hey, we use these AI tools. A lot of states um, put a lot of reliance on informed consent and notice when it comes to consumer privacy. Um, And there are maybe HIPAA implications as well to the extent that tool is taking in a lot of HIPAA protected data. Where is that going? And you want to make sure that it's not getting out into the universe unexpectedly.
Yeah, and I think the other thing that we've heard too is how long is it stored at that company too, and
Right.
so there's concerns or questions about that aspect too.
For
I
sure.
want to thank you, Jennifer, for a wonderful presentation. Thank you so much. It was excellent. I want to thank everybody here that was participating, and thank you all for being here today. I do want to just mention a couple other things that are upcoming. October 15th, we'll have a regulatory hour with Dale Atkinson on final orders. And then we also have our annual education meeting for FSBPT. That'll be October 23rd through the 25th. Some of that will be virtual so that people can participate on with some of the keynotes if you're not able to be there in person on the 23rd through the 25th. And then also in November on the 18th, Paul Welk will discuss regulatory aspects of expanding PT practice into health and wellness services. And again, just thank you all so much for being here and participating in today's webinar. And again, thank you, Jennifer. Really appreciate it. Did a wonderful job. So take care, everybody. Thank
Thanks,
you.
everyone. Bye.